Hi everyone and welcome back to another video. Now in this video we're going to talk about Axel Rudakubana's sentence after he was sentenced on the 23rd of January 2025 to 13 life sentences, including 3 minimum terms of 52 years for the murder of 3 young girls, as well as the attempted murder of 10 other people, including 8 children. Now in this video I'm going to go through the judge's sentencing remarks to explain how he came to the sentence that he did, and I'm also going to cover why the judge was unable to give Rudakuabana a whole life order. Welcome to my channel Andy on Crime, where I talk about high profile criminal cases and other aspects of criminal law in England and Wales. And if you do want to support my channel, then please click the link in the description below and sign up to NordVPN, where you can get discounts on a huge range of their plans, and you will be supporting my channel as well. With all that being said, let's get into the video. So starting off very briefly with the facts of this case, which I know are very widely known, but it is useful to recap. On the 29th of July 2024, the then 17-year-old Axel Rudakubana carried out a brutal knife attack at a Taylor Swift themed dance class for children in Southport in England, resulting in the deaths of 3 young girls: BB King, who was 6, Elsie Stankham, who was 7, and Alicia da Silva Aguirre, who was 9. In addition to the murders of those 3 young girls, 8 other children and 2 adults sustained serious injuries at the hands of Rudakuabana. He was arrested shortly after the attack and then was charged with 3 murders and 10 attempted murders. Now, at his initial hearing, he refused to enter a plea, so not guilty pleas were entered on his behalf. And on day 1 of his trial, on the 20th of January 2025, Rudakuabana changed his pleas from not guilty to guilty at Liverpool Crown Court. On the 23rd of January 2025, having been removed from the court twice due to his disruptive behaviour and not being present for the actual sentencing, the judge sentenced Rudakuabana to 13 life sentences, including a minimum term of 52 years, and he is unlikely to ever be released from prison when he is eligible to apply for parole at the age of 70. So I'm now going to turn to the sentencing remarks of the judge and go through them and explain the sentence that he awarded. And I've put a link in the description if you want to read those remarks in full, and I would encourage everyone to do so. I'm also going to answer the question of why the judge was unable to give Rudakuabana a whole life order. Now, the first 5 pages of the 11-page sentencing remarks deal with the background to this case, and the full factual background to this case has also been widely reported in a variety of media. I'm going to start looking at the sentencing remarks at paragraph 26, which is on page 6. Now, here the judge outlines that he accepted the prosecution's conclusion that this was not an act of terrorism as defined in relevant terrorism legislation. Now, for it to have been a terrorist act, it would have had to have been shown by the prosecution that Rudakuabana committed the murders in furtherance of some sort of political, religious, racial or ideological cause. This was not the case in this case. Rudakuabana simply wanted to kill as many children as he could, but not for any perceived cause. The judge did, however, state that the acts committed by Rudakuabana were akin to a terrorist act, and highlighted that his level of culpability and harm were at the highest possible levels. Now, paragraph 27 outlines perhaps what is the most relevant factor in this case in the determination of Rudakuabana's sentence, certainly the most determinative factor, the fact that he was 17 at the time of the murders. And the judge highlights here that this is the factor which meant that he could not award a whole life order, when he almost certainly would have if that was not the case. And you might be thinking to yourself, quite justifiably so, why can he not award a whole life order to someone who is 17? Now, to answer that question, we need to refer to international law, specifically the United Nations Convention on the Rights of the Child, which is an international treaty signed by the UK in 1991. Now, this has nothing to do with the European Convention on Human Rights. This is a separate treaty underpinned in international law. Now, interestingly, this treaty has not been fully incorporated into UK domestic law. What this means is that the UK is bound by the terms of that treaty by convention, but its provisions are not directly enforceable in UK courts, unless of course they have been specifically implemented through domestic legislation. So as an example, under the European Convention on Human Rights, that has been enshrined in domestic law by the Human Rights Act. This treaty, the United Nations Convention on the Rights of the Child, has not been passed through domestic legislation. Now, Article 37 of the United Nations Convention on the Rights of the Child states that, and this is clause A, no child should be subjected to torture or other cruel, inhumane or degrading treatment or punishment. Neither capital punishment nor life imprisonment without the possibility of release shall be imposed for offences committed by persons below the age of 18. So the judge has applied international rather than domestic law when determining the appropriate sentence for Rudakubana. Now, this is not said as a criticism of the judge. Indeed, judges routinely have to give consideration to international or European human rights law. It's just worthy of note that this is not directly legislated for under domestic law. Indeed, in my previous video, I talked about the likely sentence of Rudakuabana, and I was wrong when I said that a whole life order was an option. Well, when I say wrong, if the judge had given a whole life order to Rudakuabana, he would have not contravened any domestic law, but he would have contravened international law. So returning to the judge's sentencing remarks at paragraph 30, the judge highlights that the starting point for each of the murders was 27 years. This is because under the Sentencing Act 2020, Schedule 21, which is where you go through the determination for a life sentence, he was 17 at the time, so that is the highest starting point. Now, when a judge determines the starting point for an offence, they then look at aggravating or mitigating factors which might push a sentence up or down. And the judge highlighted 7 aggravating factors which applied in this case. The first factor was that there were 2 exceptionally high factors which would ordinarily have required a whole life order, but for the age of Rudakuabana: the murder of 2 or more persons and the involvement of a substantial degree of planning. The second factor was that the children were particularly vulnerable because of their age. 3 was the physical suffering endured by the children. 4 was the fact that there were 3 murders. 5, the fact that there were 10 attempts to kill other people. 6, the severity of the injuries caused to the victims. And 7, that he had also produced the poison ricin, which he was likely to use. Now, in terms of mitigation, the judge found very little aside from his age, which had prevented Rudakuabana from being given a whole life order. And the judge also stated that he would award some small credit or reduction on his sentence at paragraph 36 to reflect the fact that Rudakuabana had pleaded guilty on the morning of his trial. At paragraphs 37 to 42, the judge goes through the other non-murder offences. For the attempted murder offences, he found that Rudakuabana was what's known as a dangerous offender. And that's perhaps obvious to people watching this video, but has a specific legal definition and allows the judge, on finding that someone is a dangerous offender and having committed what's known as a specified or qualifying offence, allows someone to be given a life sentence for an offence that is not murder. An attempted murder does not automatically attract a mandatory life sentence in the same way that murder does. Now, at paragraph 43, the judge goes on to explain the sentences that are to be imposed. For the 3 murders, so that's counts 1, 2 and 3 on the indictment, he awarded a life sentence for each offence with a minimum term of 52 years, which, deducting the time already spent in prison on remand, came to 51 years and 190 days. And those sentences are to run concurrently, so at the same time as each other, rather than consecutively, which is one after the other. And there is guidance on the application of concurrent versus consecutive sentences, and where the offending is in a single incident, that will usually attract a concurrent sentence, as is the case here. And for the other offences, he was given a sentence of 18 years for each of the attempted murders against the 8 children, and 16 years for the offences of attempted murder against the 2 adults. Again, all of these to run concurrently alongside his other sentence, as well as 18 months for the other offences. And the judge concludes on the final paragraph of his sentencing remarks, saying it is highly likely that he will never be released from prison. So to summarise, Axel Rudakubana was given 13 life sentences, including 3 minimum terms of 52 years for the murders of Bibi, Elsie and Alicia. He was unable to be given a whole life order because of the United Nations Convention on the Rights of the Child, which the UK ratified in 1991. It states under Article 37 that no one under the age of 18 can be given a sentence of life without parole. When the judge came to deciding the appropriate sentence, he found that the starting point for the 3 murders was 27 years, given Rudakuabana's age of 17 at the time of the murders. Because of the 7 aggravating factors, this increased the sentence to 52 years, even after the judge had deducted some small credit after Rudakuabana pleaded guilty on the morning of his trial. He was also given separate sentences of 18 years for the attempted murders of 8 children and 16 years for 2 adults. And in addition, the 2 offences of possessing an Al-Qaeda training manual and producing the toxin ricin, he was given 18-month sentences. Those sentences are all to run concurrently to each other, so Rudakuabana will be eligible to apply for parole at the age of 70, but as the judge stated at the final paragraph of his sentencing remarks, it is highly likely that Rudakuabana will never be released from prison. That's all for this video. If you do have any comments, then please drop them down below. If you did find this video informative, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.